With your lordship's permission, may I be permitted to make one request, Miloj? I am Anvesh Srivastav, appearing on behalf of the Metro Rail Corporation, Miloj. We had filed a caveat, although we could not file it physically, Miloj. We have the provisional ID with us, but I am unable to hear the arguments placed before your lordships, Miloj.
No,
Neither,
the arguments have not started yet.
Miloj.
We were discussing that whether the companies who have been declared responsive for a financial bid are necessary parties or not.
Miloj.
Now, Mr. Agrawal has said that that can be cured at a later stage also. That this is what it has transpired so far.
Miloj.
So, Agrawal sir, what
Yes.
is your? Yes, sir.
Yes, but the petitioner block is a central government undertaking block and is executing block all the major metro rail projects throughout the country. Block. The description of which we have specifically given block in para 5.5. The block here the controversy is not that I am not technically qualified in respect of this project block. But I straight away not come down to clause 10.2, which is 100, which is at 104. Eligibility qualification criteria, they say EQC 104.
They have not given us a copy as yet, Miloj.
We never knew you have filed a caveat.
Sir, once you had filed a caveat, sir, then you, instead of joining the proceedings through video conferencing, you should have come.
I apologize. I duly
because suppose if we say, okay, serve him a copy, then again we will be required to reassemble after 1 hour.
Miloj.
Mr. Agrawal started his argument by expressing that otherwise he would not have caused inconvenience, but looking to the urgent nature, this request was made for listing. Now you people are not ready to come down to the court. Now you are making a complaint. Now suppose if I ask Mr. Agrawal to serve you a copy, then again whether we will not be required to reassemble after 1 hour.
My name did not
Sir,
get it.
So, no, sir.
I leave it to you, Lordship.
Sir, this hybrid facility is not meant for young lawyers.
I bow down to it, Lordship.
It is meant for those lawyers who find it difficult to appear either because they are not available in the town or because of their health issues.
No,
It should not be used by the young lawyers who can come down to the court. But what can we do now?
I'll argue with the NIT that I have.
Okay. Mr. Agrawal was referring to page number 104.
Yes. Not this is the work experience which I am required to qualify. Not I'll read 10.
Sir, whether any reasons have been assigned?
No reasons have been assigned.
Mr. Anvesh?
Miloj.
It is the contention of Mr. Agrawal that no reason have been assigned in Annexure P17.
P12 Milord. P12 is the impugned order at page 850.
Okay.
Page 150. 850. P12.
So this is are considered substantially responsive and compliant to the requirements of the tender conditions. And so P12 is under challenge, sir?
But this is under challenge, P12.
P12, no?
Yes.
Yes, Mr. Anvesh, whether any reason has been assigned for holding that it is not technically sound or it is not technically fit to participate in this contract?
Well, the instructions that I have, in every NIT of Metro Rail Corporation, this has happened. This issue has reached this honorable court earlier also, There is a clause in the by the number of 7.3.1, wherein which relates to the notification of the award.
Sir, that's right. That's right, sir. We know the scope limited scope of judicial review in contract matters.
So the reasons for
please listen to us. We know the limited scope of judicial review in contract matters. So we will confine ourselves within that scope. Now, suppose if a company, which according to it is an experienced company having executed or executing multiple similar type of contracts, right? ये ऐसा होता है कि भाई ये first time somebody is trying to step into this business and then we can assume कि भाई नहीं है इनके पास कोई experience.
ये जितनों के successful technically they are my I am their employer's blood. I am executing all major projects throughout the country.
Fine. There is no difficulty.
And in the state of Madhya Pradesh, the respondent plot for
Agrawal sir, just bear with us for a few minutes.
yes.
So, Mr. Anvesh,
Malaj.
whether the company who is declared unfit to participate in this contract, not unfit in perpetuity, वो तो फिर
Malaj.
blacklisting हो जाती है.
जी.
So, to participate in this contract, right? And
Malaj.
according to the company, it is executing or it has executed major similar projects.
Malaj.
And according to them, it is a subsidiary of central government also, right?
Malaj.
Now, once they have challenged their disqualification or holding of non-responsive,
Malaj.
now in absence of any reasons, are we in a position to adjudicate the correctness of your decision? Your decision might be right. But
Malaj.
in absence of any reason, are we in a position to assess your evaluation, because we cannot go into the suitability. It is your prerogative, right?
Malaj. Yes, Malaj. But to that
Whether they have been rightly held non-responsive, to that
Malaj.
extent, or the decision-making process, that can be looked into, no difficulty.
Definitely.
For
Malaj.
that purposes, we are required to know the reasons for holding such a company as a non-responsive.
Malaj.
You could have done so without disclosing reasons. We are not on that issue.
Malaj,
But
the
that's what-
suitability aspect, so far as that suitability aspect is concerned, Malaj, so far as the disclosure to the petitioner is concerned, there is a specific clause which says that disclosure will be done only after financial bid is opened.
Sir, okay. Suppose if we say that the final decision in the contract shall not be taken, right?
Malaj, this is a mega project.
Mr. Anvesh, you yourself has said that as per the tender, the reasons will be disclosed after the financial bid is open, right?
Malaj.
Fine. Now as per the petition, the financial bid will be open on 29th,
Malaj.
right?
Malaj.
Now even according to you, you can or you are under obligation to disclose the reasons after the financial bid of the other contenders or bidders are open, right?
Yes, Malaj.
Now, this is the amount which has been filled up by the companies or bidders.
Yes, Malaj.
Now, suppose ultimately you are directed not to finalize the contract till 4th of November. So we have assembled because of the urgency.
Malaj.
And 4th of November will be the first day after the normal functioning is resumed.
Malaj.
Right? Now, as per your contention, the reasons will be disclosed after the financial bid is open. So, by the next date of hearing, even the reasons will be known to everybody. Everybody means to the petitioner, to you, and then the petitioner will be in a position to amend their petition also.